Good morning. It's 8:54. We're going to start a few minutes early because I'm going to ask a little bit off-topic question. My name is Gregory Chikalian. This is the Oil Conservation Division's second regular docket, restricted to status conferences and continued hearing by affidavits that needed some additional work and review. Dean McClure is with us, not on camera, but he's listening. And he can participate if necessary. Freya is running the show, and we've been recording for, I think, about an hour now. So, before we get into our docket, I thought I would ask the regulated community for some feedback on the new procedures that we noticed beginning November 1st for two of them and December 1st for one of them. And I thought I would just go around the room. I'm going to start from my left and go to my right and just get some feedback while Freya and Dean are listening so that we can give IT some feedback as well. So let's start. Good morning. Oh, Jackie, you want to, for Hardy McLean, you want to chirp up? All right, sounds good. Please keep, no swear words. And please keep.
Everyone knows I don't I don't swear.
Please keep your comments limited, short. Just give us the high points of the ups and downs of the three notices from your perspective. So Jackie, go right ahead.
Okay, thank you. First, I will begin with the filing system. I personally file regularly, and one thing I know that we had heard that it was not meant to be required to input things like the pool and pool code, but you can't submit an application for a new compulsory pooling application without completing every single one of the boxes except for the facilities one. That's the one that you don't have to do. If you're filing a reopen application or an application to amend an order, you do not have to fill out everything. All you have to fill out is the notice portion and attach the PDF of the application. Secondly, there's no function on the OCD website to administratively request an extension of a pooling order. We have reached out and asked for that because the part of that I thought was to streamline things and take cases off the docket. We're continuing to have to come for that. So adding that function would be very helpful, or giving us an email where we can submit those administrative requests for an extension. That would be helpful. Lastly, the ownership commitment exhibit, that was also part of the notice, the group of notices that went out. If someone could explain the reasoning, that would be wonderful, but it seems to be a compilation of exhibits already in existence that's creating more time and work for many of our, administrative assistants, clients, and ourselves that have to check these. We already have the notice that was sent out as a notice exhibit that's required. The unit recapitulation exhibit with the pooled parties list that shows who's committed and who's not committed. So it would be nice to not have to do that additional work, as we're already being asked to take additional time to file the applications now, because the filing is a very, very lengthy process. To do one simple application can sometimes take 20 to 30 minutes to file. So that's what I have to say.
Thank you. Thank you. I'm not sure who you are.
I'm Rayleigh Starnes with Holland and Hart, and I know that Paula
Okay,
can speak to this more effectively than I can.
All right. Yes, and please do it in the same format that Jackie McLean. Well, I guess let's go with Dina Bennett, since you're technically next in line. If you'll do it in the same format that Jackie did, it's succinct, and it just alerts Freya and Dean on what issues you might be having, so we can go to IT and see if we can get that fixed.
Thank you. On the filing, and this might not be a question for IT, but with the pool and pool code, I'm curious about whether if we enter the wrong pool and pool code, our application's going to be rejected at hearing, because a lot of times we are working off of preliminary information on the pool and pool code at the time we're filing the application. And so this is not necessarily a question for IT, I don't think, unless we could bypass the pool and pool code at the time.
Freya?
Yes, we are aware of this issue, and it wasn't the intention of the division to require the pool code to be mandatory. IT is working to correct this.
Thank you. On the extensions and amendment to the development plan, I echo Jackie's comments that my reading of the guidance and of the orders was that it was to be streamlined and we wouldn't even need to submit a hearing application. And so the fact that we now have to submit a hearing application, not now, we were all the time having to submit hearing applications, but so it doesn't seem like it's that much of a gained efficiency. And then I do have.
Hold on one
Sure.
second.
Mhm.
Freya, is there someone who could be muted? It sounds like someone's moving papers around in the
I
background.
muted it.
Oh, thank you.
I-
Okay.
As you know, that irritates me when I hear background
Right,
noise.
right. Go ahead. I'm sorry, Ms. Bennett. So back to the streamlined extensions. You were saying you thought it was what now?
that we weren't going to have to submit applications through the portal at all, that there was going to be an alternative mechanism for us to alert the division
Sure.
to uncontested.
But how would you know it's uncontested if?
We are obligated under the orders, not we, but our clients through us, to send out notice 20 days in advance. And so if there's no protest during the 20 days, then I'm going from
Yes.
memory on
Yes.
the orders here, then the amendment or extension was, as I read the orders and I think it was the July guidance, the amendment and the extension was deemed approved. And so I did raise a question with the division about how to memorialize the deemed approval, but that shouldn't have, in my mind anyway, led to having to file an application with the division, taking the division's time to just say, this has not been protested. So that to me seemed, the guidance that we received seemed inconsistent with the intent of the language in the order and the earlier guidance on it.
Okay, so let's go back for a moment. So in the old way of doing it, every extension had to be filed with an application to the division. And if it wasn't protested, we'd still hear it by affidavit and blah, blah, blah. Okay, so we were trying to avoid having to do a lot of these extensions by hearing. So then in your mind, how would that be done?
So what I was thinking is we would send out the notice
Yes.
and we would notify OCD as well. That's what the orders require, is notice to the parties and notice to OCD.
20 days?
20 days.
Before what?
You won't, 20 days, I guess, before would be deemed approved.
Well, hold on, but the 20-day notice, isn't that normally, hey, there's going to be a hearing in 20 days? That's
No.
not what, that's not
No.
the 20 days.
No, I wish I had an order pulled up. Maybe someone can pull up an order for
That'd be
me.
great. Is there a
But
rule that you're citing?
no, it's in the order.
Notice.
It's in the notice and the order.
Yeah.
New orders.
Let me log in and get the
Okay.
notice up in front of me too.
But I think the newest orders would be the most helpful for you to look at because they predate the guidance.
Oh,
So the
I see.
orders
So in
are
the orders that you're
inconsistent with the
extending,
guidance.
They say, if you want what do the orders say?
The orders say, if you want an extension, provide notice to the division
Yeah.
and the other parties. And if there's no objection within 20 days, then the extension is approved.
So this is on the order
This
itself,
is on the order itself,
not in the rule.
not in the rule and not in the guidance.
And that's why I don't know about it, because I
Yeah.
haven't looked at that order yet. Okay,
It's in every new order for the last year and a half, I'd say.
so then with that order and with those words,
Mhm.
you're hoping that the system would be what?
That
Send
you
out your
would
notice.
send out the notice and the notice would go to the division and to the parties. And at the end of the 20 days, we could file something in the case files, an exhibit or an affidavit from the lawyer saying, I complied with the notice. The notice, there were no objections, and it is now
I put it up on.
deemed approved. So here it is. so it says the operator requests an extension by notifying OCD and all parties that required notice. Upon no objection, after 20 days, the extension is automatically granted.
So what happened to good cause? What do you mean automatically granted?
There's no good cause anymore. Good cause is out the window.
Oh,
Based on the language. of the-
Yeah, based on the language of the order. I'm not saying good
right, no,
cause.
I get it,
yeah.
I get it.
And then it says, if a protest is received, the extension is not granted, and then we set the case for a hearing. But under the guidance, we now have to file an application for a hearing, even if it's by affidavit. So
Okay.
it's inconsistent with
Okay.
paragraph
Well,
21.
this is why I asked to
Mhm.
do this morning, because I wanted to hear your feedback.
Mhm.
This is a good one to think about. Is there anything else you wanted to say?
Yes, on that same thing, it says that you're supposed to give notice to the parties in accordance with X, Y, or Z. And back in the day, for extensions, we only gave notice to working interest owners. Then we gave notice of extensions to everyone who was given notice before, like the entire notice list. And now folks are doing a combination, I'd say. Some folks give notice of extensions only to the working interest owners that were pooled. Some folks give notice to everyone who was pooled, including overriding royalty interest owners. And so I think it could be helpful to understand from the division exactly what notice is required for an extension or amendment.
I asked Dean McClure if he'd like to address that issue. He says when everyone's finished with their feedback, he will then give some sort of guidance. I guess there is also an FAQ email that is still before the director that has not been sent out yet, just so you know.
Thank you.
Which I know may clear some of this up, but that seems like a good one to clear up now if we can.
Yes, and then finally on the notice exhibit,
Mhm.
I understand where Jackie's coming from on that, but I don't see any issues with that, and I'm having no problems filling that out. And I understand the reason for requiring that.
Thank you. And Ms. McLean, I was listening to you before and I thought that the additional part of the exhibit was the voluntary commitment part of it.
So on the, or at least how pretty much all of ours
Yeah.
work, our exhibits work, are that we show whether or not people are voluntarily committed or have committed to the unit. The only way you can commit is voluntarily, or I guess if you have already are subject to a JOA, but then you wouldn't be being pooled. So you wouldn't be being pooled, like that wouldn't really matter
But I
for
think
the
that
purposes
that
of the hearing.
inference that you're referring to is an inference that the division didn't want to keep making. I think the division wanted affirmative evidence to show who was voluntarily committed, not necessarily, show us a JOA or something like that. That's way too much, but just affirm under your ethical commitment to the forum that this party is in some way voluntarily committed or not. I think it was that extra step.
Then maybe we could just put that next to their name on that exhibit, because I don't know, to me, it just doesn't, I understand if they want some sort of indication of how they're being committed or, what's going on there, if it's through contract, if it's verbally, I understand that.
Okay.
But the landman doesn't send out the notices of the hearing, and they're asking that this be attached to the landman's
Map,
right, their testimony. And so we have to take what we've already
see.
put together and then add it to that exhibit and then add additional we used to do it that way where the landman would have the notice that was sent out for the hearing attached to their testimony. And then the division said, no, you guys need to start submitting your own affidavits
I
that
see.
attach
I
that.
see.
So now we're going back to both. Now we're doing both.
I see.
And
Okay.
so if they want that affirmation, I understand that, and that's fine, and we can provide that. I don't understand the need to add that hearing notice aspect to the piece, because that's just making us do that list twice.
We'll see if Dean wants to chime in on that as well. I'm not I'm not volunteering him. I'm just saying, we'll see. It's up to him.
Mr. Examiner,
Miss-
could I just
yeah.
weigh in on what Ms. McLean said?
Yes.
I do recall, I mean, I was involved in a hearing that I think probably led to the creation of this exhibit, which is where an operator had reached a letter, not a JOA, but by voluntary oral agreement had agreed not to pool a party. And the division was concerned that whether that rose to the level of being committed such that they did not need notice.
Right.
And so I think, at least when I read that exhibit requirement, that's what it was designed to address, is both folks who, committed via a JOA,
Right.
but also giving us the opportunity to identify when there's letters of support or oral agreements, such that the fact that they weren't given notice of a hearing may
Right.
not preclude dismissal or a continuance to cure notice. So I find that exhibit to be, while I agree, it's probably better in the lawyer, in our affidavit than in the landman affidavit. I understand the purpose of it and think that it can be helpful for us in those situations where we may have not given notice for a reason that's not entirely clear to the division through our exhibits.
Yeah, thanks for the clarification. I do see Dean on, so I guess but let's go to Ms. Vance next.
I will keep it brief because I think a lot of my feedback has already been
Okay.
covered. But I would say, yes, starting with the filing, it's exceptionally time consuming. And for us, and I think a big concern is if we don't get the information input correctly, especially since I hear Ms. McLean, she's filing, Ms. Bennett is filing, we have a legal assistant who is filing, who is terrified that she's going to mess it
Right.
up. And so putting that pressure. Yeah, it's a lot of detail. And so there's a lot, whereas before it was a very seamless process. And now we're doing a lot of checking, rechecking, and making sure. And again, that concern that, especially with the pools and the pool codes, because sometimes we come to hearing and we find out
Sure.
we don't have the right pool or pool code. Will it be rejected, or is there an opportunity to correct that so that we can still move forward? Is there a process for that? I
Not to
think,
interrupt you, but let me just let you know that before we asked you to enter your own data, literally one person was entering all this data.
Mhm.
And it was no, really. And you think to yourself how it feels if you got it wrong. I mean, she doesn't even work for the client and she's trying to get it all right. And she did a great job and didn't make very many mistakes. Along the way, we asked ourselves, well, what happens if we find a mistake in
Mhm.
data that you or your assistant has entered? How would we deal with that through the process? Okay. And we've been talking about that, and no, it would not derail. And as you see, we've bent over backward in trying to correct mistakes or help you correct mistakes without our correcting them, where there's a slight delay. It may be a couple of weeks delay, but it's not like you have to wait even a whole month to get that case taken under advisement. So we're working on it.
Which I would say we very much appreciate, and getting that reassurance
Sure.
from the division is definitely helpful. And I think you're referring to Freya, maybe, who's
course
been
I am.
entering.
Of
And
course
so
I am.
we applaud her for that, and we thank her for doing such a wonderful job. But yeah, it's obviously a change, and having that, particularly the reassurance that an application is not going to get rejected, is nice. Okay, and then moving on to the extensions, again, I'll just reiterate everything that's
Okay.
been said.
Okay.
Having that, it would be nice to understand that, so that we don't have to file applications. I won't repeat everything that's been said. The evidentiary notice, I would definitely say, I understand the reasoning, I think, behind it based on the discussion here and, my own thoughts of observing. But I do think it's a lot of back and forth with the client. And if we are going to include it, it's much better for it to be in the attorney statement and not in the landman statement, because it takes just additional coordination and sometimes can lead to some confusion in making sure that the information is correct. I don't think it's an issue doing it.
Okay,
But if we are going to do it, I would definitely highly recommend that it go in the attorney
Okay.
state with the attorney statement. Thank you.
thank you. Mr. Padilla, do you have anything?
I don't have anything new to say.
Okay.
All I can say is, by way of comment, is that it seems to be easier to file in the federal district court than oil conservation division.
That's because you're used to doing it
Yes.
as a plaintiff, I'm sure.
Um, I think I would have to, I collaborate with Ms. Luck over here, and I haven't had an opportunity to file applications, but I'd have to relearn everything and do it correctly.
Okay. Let me hit the back of the room before I come back to you, Ms. Vance. Ms. Luck?
Oh, I don't have anything else. Thank you.
Okay. Thank you, Ms. Luck. Mr. Rankin, anything else from Holland and Hart?
I just want to say initially, thank you very much for giving the council who practice regularly before you the opportunity to comment. I think it's really important to do that. I'm grateful for the opportunity.
Thank you.
And I think whenever the division is considering making changes or making pronouncements or taking a different direction, I think it would be very helpful and useful if in advance of that, they take the opportunity to seek input and comment from the council. I think it's an opportunity for us all to come together and streamline the process where possible. To that point, I'm still confused why we are having to ourselves enter the pool code and pool names. To me, it's an administrative thing that the division manages behind the scenes. There's no publicly available information about pool codes, where to find them, what they are. They constantly are changing. Clients are frustrated by that because they think that they've called and find the pool code and they find out they're wrong, and then we have to amend it and sometimes often come back to hearing. And let me just say that the amount of time that has been eaten by that, both I'm sure on your side and our side as well, and the client side, is substantial. Substantial. I mean, it's just absolutely mind-boggling that we have to do that, I think. And just to be not with all respect, I think it would be very easy. We know the formation, we know the acreage, and if the division upon issuance of the pool of the order could simply attach the correct pool to code to the order, it would solve so many issues, streamline the process, and make everybody's lives so much easier. I believe the divisions as well.
Thank you. So Freya, I know IT is working on the pool code issue. What will happen after they fix it?
It will allow submitters to submit an application without selecting a pool code.
Okay, and how will that correct pool code get entered along the way?
I'm not sure. That might be a better question for
For
Dean.
Dean.
Yep.
Okay, yes, Dean, we have lots of questions. Okay, anything else, Mr. Rankin, before we go to Mr. McClure?
Well, just on a couple just points, just for historic perspective, and I feel a little silly being the one providing that here, but I mean, I'll just say, like, prior to 21, when an applicant wanted to or sought an extension for a pooling order, it was done by submission of a letter to the division director stating very simply the basis for good cause. It was issued as a matter of course. Okay. Upon a second extension request, then they might ask for more details. Okay. But up for the last, all of history up until 21, applicants under a pooling order simply needed to provide a very simple cover letter solely to the division director asking for an extension. That all changed in 21. And since then, it's been in a matter of great, turmoil, it seems to me. Okay. Now, obviously, there's reasons that parties who are pooled, there's some justification for having opportunity to come forward. If there's been a cash call and there's no drilling and there's things that need to be addressed by the division. I understand that. But I just want to put that into historic perspective, given, and I fully endorse a simplified approach.
Okay.
Where if there's no protest, then it can simply be approved. On the notice issue, again, historical context, for as long as I've known it, an affidavit from an attorney has been sufficient evidentiary evidence to demonstrate that notice was properly provided, the timeframes, the dates, the parties and so forth. And so again, I haven't studied the guidance that was provided by the division, and I'm not fully aware of the issues in the one case apparently that gave rise to this concern. But again, I think if there really was one case that's driving this, it seems to be the tail wagging the dog. And I think those can be addressed in those particular matters. Our clients are concerned about not knowing exactly how notice was provided because they didn't do it and having to put it in their testimony. And so from our perspective, the notice provision that's in process at the time we're trying to get these things ready to go. In other words, we're working with a vendor to get the notice out. In the meantime, while we're waiting for the returns and the information that is necessary to show that the notice has been provided and that if any have been received, we're also at the same time trying to get the statements from the clients put together, and they are asking us to provide them information that we don't yet have. Okay. Well, the process has been that, we get the statements from the landman. At the same time, we're working to get the information from the vendor on the status of the certified mailing. It all comes together in a very narrow window. Okay. Having to do this earlier to get to the clients so they can include it in their statements is an additional burden that just makes everything so much more difficult. Okay. And I don't see I don't quite understand the justification for it.
So let me interrupt you for a moment. First of all, it wasn't one case that caused the issue. Just so you know, we have been discussing this between the Hearing Bureau and the Technical Bureau for quite some time before we came to this request. What I'm wondering is, since you've just told me some of the process I have no clue about because I don't deal with the clients. It seems to me that the client has to give you a list of people that it wants you to notice. Well, they must understand, because they're lawyers or they have lawyers or whatever, that certain parties don't need to be noticed because they're voluntarily committed. I mean, how else would they know to give you a list of people to notice?
Well, it varies.
It does.
Because from the time they file the application to the time we go to hearing, there are many discussions happening.
Oh,
okay. And so from the time we go to hearing until the time we present the evidence, sometimes there are agreements reached.
Oh,
okay. Because again, the sequence is well proposal goes out under the division's guidance. Applicants are to wait 30 days before filing an application, unless extenuating circumstances arise. So there's a short period of time before most applicants file an application for discussions.
okay.
Most of the discussions will be happening from the time the application is filed until it's prepared for hearing. So it's again a tight window.
Yes, I see.
So whether they know at the time of at the time they provide notice to us, whether any party is going to be pooled or not is totally not clear, because there's still much of the discussions to come. So it's not at the time they give us the list, it's not always clear to them who's going to be pooled, who isn't. Okay. Sometimes there have been discussions in advance, given the relationships of the parties and the development patterns that are occurring, but that's not always the case.
Okay.
So, so again, I go back to the regulation that provides for who is to get notice, and it's the parties that you're intending to pool.
Right.
And at the time of the hearing, I think all that we should be required to do is to provide a list of the parties who at that time are going to be pooled, who the party intends to pool. Now, I would say again that my view is that the applicant, the risk is on them. If they have left somebody off due to an oral or any other type of agreement, if they haven't pooled them, because the statute provides if a party is not pooled, then they are to be treated as if they have been pooled or to be paid on a lease basis, whichever is greater. And so the risk entirely is on them, because not only will they have to pay them as if they've been pooled or the greater on a lease basis, or they'll have to come back and spend the time and money to reopen the case to pool them, and potentially lose the risk charge against them because the wells maybe has already been drilled. So the risk really is on the operator and the applicant. And so that should be sufficient from the division's perspective to ensure that, because there are remedies already in the statute to address that situation.
Thank you. That's helpful. Ms. Vance, the last word?
Yeah, just very quickly, I just wanted to reiterate, we did send some questions across. I sent across some very detailed questions. And I just wanted to make sure that that's a part of, or at least it's being addressed, because they're more granular than some of the, especially for the filing of what's required, that those are being addressed by I think the email that you were speaking of that's with the director. Just sort of like wanted to put a pin in it.
I'll let Dean answer that question. He has a few questions that he can answer if he wants to.
And I do just one quick other thing, if that's okay?
Another thing?
Just one quick thing. So kind of going to the cumbersome nature of having to refile, especially for revised hearing packets that include a pool that's been corrected. I don't know if this notice was rescinded or whatever, but there was an OCD notice a couple years ago that basically said if you have to file a revised hearing packet, that you do it within 2 weeks. And then if there are no further questions from the division, it's taken under advisement. And we've gotten into this process lately, especially where we do have, we need to just update the pool on the CPAC and then the C102s. We have to continue the case, come back. And that is time, for all of us and our clients. If we're doing something as simple as just updating a pool, it seems like if we're meeting that within that time frame, is it necessary for us to come back?
Well, from what you just said, and I haven't seen that notice that you were referring to, and I can look at it obviously, but it seems like there was that caveat that unless the division has any other questions,
Sure.
Blah, blah, blah. So, and what we've been doing is we've been getting these cases back within that 2-week time frame, not knowing about that notice, just to try to make this streamlined and not delay the clients. We've been doing that. So it seems like we're sort of doing, it seems like I'd like to look at that notice, but it seems like the idea is to try to streamline the process, and it seems like we're doing that already in a little different way. But I'll look at that notice.
Yeah, just the coming back and having to be back at a hearing. If there's no, especially if it's uncontested and all we're doing
Sure.
is correcting something,
Sure.
the pool or pool code.
Well, we have some we've used some discretion that, what qualifies as a typo. We've used that discretion to try to help move these cases through, but we also want to reserve the ability to further review whatever the changes are to make sure we're comfortable with those changes before we say we're taking this case under advisement. Let me go to Mr. McClure now.
Thank
Mr.
you.
McClure, thanks for appearing. I know you weren't expecting to appear. Address whatever you want in any order you want.
Thank you, Mr. Hearing Examiner. And I think this has been very useful because I guess I didn't realize there was quite the concerns, I guess, that it sounds like there is. A quick question for Ms. McLean. I think you're the one that sent the division, like what I've been referring to as like the FAQ email. Did that include Ms. Vance's questions? Is that correct?
Yes, that include,
Okay.
I got questions from everyone, and then I just assembled them, so they weren't repetitive and then sent them on your way.
Okay, very good. Yeah, I was going to say it's been a hot minute, I guess, since I've reviewed that and put in my feedback. And as our hearing examiner had alluded to, I believe our technical team and our hearing bureau has had its input on that FAQ email, and I believe it's in front of our director and possibly general counsel, but I think mostly with our director, and I believe it should be getting sent out in the near future, but the director's schedule being what it is, I don't know for sure when he'll get a chance to do the final click for us to actually send that out. And I don't remember for sure how many of these questions that we've just had is going to be addressed in that, because like I said, it's been a hot minute, I guess, since I've actually had the feedback on it. I was going to say, first off, though, I know on the extensions of time submission, I believe this is covered in that, but just very briefly, it's not the division's intent for that paperwork to be filed as a request for a case or hearing. Excuse me. We do want it to be submitted to us in a format that is via an OCD permitting, so not an email and nothing like that. And we're also, I believe, we do not have an intent to issue any orders after that. And the approval of it would essentially be us going into the system and approving that submission. And maybe some of the comments, if we do something, it'd be something we'll probably put directly into the case file ourselves, would be my assumption. But having said that, I believe the FAQ will cover more in depth as to what type of filing to do it as. I believe it's either going to be that post-hearing submission or what their IT is now calling compliance review or compliance report or something. It's one of those type of submissions, not a request for a hearing. So it should be completely free, just a matter of your guys' time to get it submitted. I believe, I think we've already kind of addressed here, I believe the pool name and pool code thing, I believe IT, I thought maybe they already had it fixed, maybe not, but I know they're definitely working on it to make it so it's no longer required to be put in by you guys. And the process thus far is for the technical staff to go in and input that into the system. Now, having said that, if the applicant is going to provide a pool, then it's going to be on that CPAC. And if you provide the incorrect pool, then you're going to have to be revising that CPAC because we're making that a part of the order. So it is important for that to be correct. And I believe I've said this to a few people before, but just to make sure everybody is aware, if you have any questions as to what pool is correct, then feel free to email myself and I'll get that for you before the need to submit anything. So feel free to reach out and I will provide that to you. And if I somehow forget it, feel free to keep emailing me until you get a response. And I will get you the pool name and the pool code for specific sections and formations. There's no big deal there. On the commitment table, I believe our hearing examiner kind of led into what the purpose of it, of what the purpose behind it is. And essentially that is strictly as an aid for the technical staff in regards to the rule that 1A, where it talks about anybody that is not committed must be noticed. It is our intent for the landman to tell us who is committed. And that's something that I would assume the landman should know because they're the ones making the determination of who is voluntarily committed. It doesn't need to equate one-to-one to the notice. The landman doesn't need to testify about the notice. All we want from the landman is who is committed and what the methodology is of that commitment. If it's a JOA, write JOA. If it's letter of support, write letter of support. If it's a restaurant napkin with a signature from the landman saying, I agree to everything the applicant said, then tell us that as well there. And essentially the division will use that and apply it directly to making a determination under that Rule 1A as to who is required to be provided notice. Has nothing to do with who is being forced pulled or requested to be forced pulled. It's directly about who the landman is telling us is committed. The there won't be any reconsideration as to putting it into the attorney's affidavit because we're wanting to know what the applicant is swearing to. I don't know if that led into any further questions or thought process of the one I just said there, but I think that was everything, was it not, Mr. Hearing Examiner?
Yes, Mr. McClure. And what I'd like to do is if there's any questions based on what Mr. McClure just said, because I'd like to get to our docket, send them to Mr. McClure and copy me so I can see them as well. And we'll try to continue to improve on what we have already imposed on the regulated community, because we want to make this better, but we don't want to make it, hard to deal with. So that being said, thank you for everyone's input. I appreciate it. And let's go on to our docket for today. We'll start with some status conferences. Let me get my docket open here. All right. I hope this is in the right order because this is not the worksheet that Freya sent. This is something else here. So I'm going to call case number 25707. No, that's definitely wrong. Let me find another email from Freya. Here we go. Worksheet. Got it. Thank you. It's here and I appreciate it. Thank you very much. But I finally found what I needed to find. Let me just enlarge this thing so I can see it. Let's start with Powderhorn Operating. This is case number 1 on our docket. It is 25610. It's joined with 25753 and 54. Entries, please.
Morning, Mr. Examiner. Ben Holliday on behalf of the applicant, Powderhorn Operating in 25610, which I believe we're going to consolidate with the next two on the worksheet.
Yes, that's why I called the 3 cases together.
Okay, sorry.
Good morning, Mr. Examiner. This is James Parrott with Beatty and Wozniak representing Coterra Energy, Magnum Hunter, and Cimarex Energy.
What's your position, Mr. Parrott?
All 3 parties have entered appearance and objected to presentation by affidavit.
Okay, and objected for what purpose?
There are essentially 2 different units, 2 formations per unit, and in all 4 matters, there are plans to present an alternative development plan.
Where are they in their alternative development plan?
They are sending notices or have sent, or proposals rather, or have already sent proposals, kind of depending on which formation, which unit we're talking about.
Mr. Holliday, has your client received proposals?
I'm not sure if they've received the proposals. I know there's been active discussions between Coterra and Powderhorn, and my understanding is that a letter of intent has been reached between the parties for this case.
Mr. Parrott?
I don't think the letter of intent is signed. My latest update from my client is that the parties are more or less aligned on terms, but nothing has been signed yet. And I apologize, I misspoke. Counter proposals have not been sent. They've been prepared and are ready to be sent, but I believe that Powderhorn asked Coterra to hold off sending proposals, given the progress on negotiations thus far. So proposals haven't been sent, but are ready to be sent. And the parties, I think, are progressing well toward an agreement, but have not signed anything yet.
All right, let's get other entries of appearance.
Good morning, Mr. Examiner. Caitlin Luck appearing for Avant Operating 2.
Your position?
Avant has objected to Powderhorn's cases proceeding by affidavit. It's our understanding that the cases would be set for a contested hearing. Avant has filed competing applications yesterday for both the Bone Spring and the Wolf Camp. I don't have case numbers assigned to those polling applications yet, but Avant's competing polling applications are on file because the well proposals went out some time ago.
So, Mr. Holliday, did your client receive these proposals that would have gone out about 30 days ago from Avant?
I'll have to check to see if the proposals have been received. I'm sure the guys can shoot me a message here while this hearing's ongoing. I did receive notice from Ms. Luck yesterday that the proposals have, or excuse me, the competing applications have been filed. Okay,
And
yes, we
Freya?
did. I'm sorry, real quick. Powderhorn did receive the proposals referenced by Ms. Luck.
All right, thank you. I wonder where we're getting this from. It's
mean-
cute, but hopefully it won't continue. Freya, is it in your queue?
Yes, I believe there are 2 applications that were just submitted yesterday. They have not been processed yet.
That's fine. Okay. So you'd like them to be consolidated with these 3 Powderhorn cases?
That's correct. Avant has one application for the Wolf Camp and one for the Bone Spring.
And you'd like them to be consolidated with these
Yes, Mr.
3
Mayor.
cases? All right, sounds good. Let's continue. Any other entries?
Yes,
Yeah.
good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Marathon Oil Permian or Marathon Oil Permian, sorry. Yes, so we filed an entry of appearance and objection. Proposals went out yesterday for both the Bone Spring and I believe the Wolf Camp. And that would be, those competing plans are in the northeast quarter of section 3 and then the north half of section 2. So, just giving a little
You mean they
description.
overlap in?
They overlap with Powderhorns. They do not overlap
see.
with Ms. Luck's clients' proposals. And so, yes, we are objecting, obviously. Like I said, those proposals just went out. So filing for applications wouldn't be ripe for another 30 days or so. And then beyond that, having another 30 days to before a hearing. So, for Marathon, we'd be happy with another status conference, but also we would be requesting a contested hearing date sometime in March or April, late March, early April.
Yeah, I don't think I could do April. The date in March that's available is March 10. So Mr. Holliday, Mr. Parrott, Miss Luck, think about March 10, because I'm going to ask you after all these entries of appearance. So thank you, Ms. Vance. Any other entries of appearance?
Yes, Jackie McLean on behalf of Permian Resources, and we are just entering our appearance. We haven't objected.
Wonderful. All right. So it looks like,
Mr.
there's more.
Examiner,
Yes.
Jim Bruce representing Kaiser Francis Oil Company. Kaiser
Okay.
Francis objected, but it is not filing counter applications.
Right. So your objective here in objecting is what?
Kaiser Francis wants time to review all the competing proposals from Avant, Marathon, etc.
Okay. All right. Thank you, Mr. Bruce. Any others before I continue? All right. I'm not hearing any. All right. So, Mr. Parrott, you most likely will not be filing competing applications from what I understand.
I don't think that's an accurate characterization. I think, Coterra is optimistic that won't be necessary, but until the ink is on the paper, there's no deal, and Coterra fully plans to go to a contested hearing on a contested application, or on a competing application, rather.
All right. And your proposals have not been sent yet. Is that right?
That's correct.
Okay.
By mutual agreement of the parties, Coterra has not yet sent proposals.
So if I set this for March 10, you'll be able to comply with the rules to get that filed?
Just working backwards, that would put us about 2.5 to 3 weeks out for actually setting proposals. So I think that's a fairly tight deadline for the parties to actually sign a written agreement. We certainly would prefer to have more time, because once we get terms fully agreed on, which has not completely happened yet, we actually have to turn those terms into a written agreement. I guess, you made a comment a moment ago that April is not available for hearings. Is that,
Mhm.
is there are no hearings happening in April, or it's just full already, or what's?
It's not a
going on?
date that it's not a date that I'm offering. The date that
Okay.
I'm offering for these cases, based on the age of the original case, the 25610 Powderhorn, would be March 10. I'm not comfortable going out past that. And it seems to me that if you have to send out proposals and then, and I mean, you don't even file the application for another 30 days after that. And it seems to me that you have some wiggle room in there.
Understood.
All right. So, Mr. Holliday, these are your three cases. I know, Ms. Luck, we have two cases of yours. And how do you feel about March 10?
March 10th works
March-
for me. I'm sorry.
Sorry, what?
Oh, well, go ahead, Mr.
I was
Holiday.
asking Mr. Holliday first.
Sorry.
Mr. Holliday?
Yes, sir. Well, we had originally penciled the 2/26 date. We conferred about that with council. I think the same discussions were had as we've just heard. Powderhorn, from Powderhorn's perspective, we've been working with the parties and communicating since, or they have been communicating with the parties since July. So there's no surprise, or no one's been caught off guard by this. There has been substantial deal progress, and from a third perspective, we have some expiration concerns in 2027 that every day matters for Powderhorn. So
Okay.
it would be our preference to keep that 2/26 date, and if that's too tight, then to no later than the March 10th from Powderhorn's
Okay.
perspective.
Freya, you wrote a list of 3 dates on a piece of paper for me, but 2/26 is not on there.
Correct. That's
Because?
that's because we already have one other contested hearing scheduled, and we anticipate kind of a longer hearing that will be scheduled shortly.
Is that Ms. Vance's hearing?
No, that's the one I emailed you about this morning.
I thought that was Ms. Vance. Which
In the same email.
right, but,
It's a NOV that will be filed up.
oh,
on behalf of-
okay. All right, so it's the
division, yeah.
division's case. Okay, the environmental case.
Yes.
All right, sounds good. All right, so Mr. Holliday, 3/10 is the earliest and only date that I can really offer you now. Can you make that work?
I believe so, yes, sir.
All right, Ms. Luck?
And yes, that works for us. Thanks.
All right, sounds good. Ms. Vance?
Yes, that works for us.
All right, wonderful.
Thank you.
Of course. Ms. McLean?
Yes.
All right, sounds good. Mr. Bruce, I'm assuming it can work for you.
Yes, sir.
All right, and Mr. Parrott?
Yes, thank you.
All right, we will issue a pre-hearing order for these 3 cases, plus we will add Miss Luck's cases because we'll know those numbers before we issue that order. And then when the other parties, Mr. Parrott and Miss Vance, if you do file competing applications, which sounds like you're probably going to, please notify us to consolidate those cases on the pre-hearing order. Ms. Vance, anything further?
That's all I was gonna get to. Thank you.
All right, if there's nothing further, we'll be in recess on these 3 cases. Let's go on to, it looks like a different Powderhorn case. This is 25722.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Powderhorn Operating.
Good morning.
Good morning, Mr. Hearing Examiner Paula Vance. Excuse me, with the Santa Fe Office of Holland and Hart on behalf of COG Operating. And we have entered an appearance and are objecting.
And your goal is?
Yes, so what COG would like to request is another status conference. And it sounds like there's maybe some negotiations that are going on. However, COG does have an operating agreement for some of the acreage involved here. So if there is a push for a contested hearing, we would not want anything earlier than April. And I know that that's not being offered, but I would like to state that for the record. Nothing earlier than April or May.
All right, are there any other entries of appearance?
Mr. Hearing Examiner, this is James Parrott with Beatty and Wozniak, representing the same Coterra group as I mentioned before. So that's Coterra, Magnum Hunter, and Cimarex.
Okay, and your position?
Essentially the same as COG's.
Okay, so you've objected, but you're not quite there when it comes to proposals.
I would characterize it as very similar to the last set of matters. Proposals have not been sent. The parties are negotiating. I think optimistic for a solution, but by mutual agreement have not yet sent proposals.
All right, okay. Any other entries? No, okay. So, Ms. Hardy, as you know, I give preference to the applicant. You have the deadlines that other people and we don't know about. And it's your case. So, how do you want to proceed?
Sure. Thank you, Mr. Examiner. The parties are negotiating and we're cautiously optimistic, but at this point, this case has been pending for a little while. So I would request that we set a contested hearing date on the March 10th docket.
Okay.
It's fine if we also want to have a status conference in January.
Okay. Okay, very good. So Ms. Vance, Mr. Parrott, the applicant has asked me to set this for March 10. That gives you, over 3 months. Well, let's say 3 months, 2.5 months to negotiate or file competing applications. We'll work with you if you do, but it seems like enough time to negotiate. So I'm going to grant that motion to set this for a pre-hearing, for a contested hearing for March 10. It'll be second on the docket. Anything further, Mr. Parrott?
No, thank you.
Ms. Vance?
No, thank you.
Thank you. Ms. Hardy?
No, thank you.
We're off the record in this case. Let's move on to case number 5. This is Spur Energy Partners, 25727.
Mr. Examiner, Dana Hardy on behalf of Spur Energy Partners.
Mr. Examiner, Ernest L. Padilla for, I have 4 clients, EML 2010 Trust, GLJ 2010 Trust, JLM 2010 Trust, and EMC Oil and Gas Ltd.
Thank you. When you speak, will you speak a little louder? I'm a little concerned that the AI won't pick up your voice for the transcript. What's your position?
Our position is that there's no creativity in terms of the offers that are made by Spur.
Okay.
The only thing that my clients have received are a proposed JOA. My clients own 2/3 of the spacing unit,
Okay.
and the 3 AFEs total somewhere around $12 million. They would have to put up $8 billion in order to participate. That's not
Okay.
good faith.
I get it. So question for you, have you objected?
Yes, we did. We objected to an affidavit hearing.
Okay, good. I wasn't sure your position in that respect. And your objective is to get a better offer.
Obviously, yes.
That was clear. All right, Ms. Hardy?
Thank you. I would request this case be set for contested hearing on March 10th on, I believe the only issue would be good faith negotiation because Spur has negotiated in good faith. Mr. Padilla's client has an interest that is overburdened by royalty.
Okay.
And so that's their issue and
All right.
we'd ask for a hearing.
All right. So granted. So Mr. Padilla, you have a little while to negotiate with your for your clients, and if not, we'll have a hearing and you can show us how they have not negotiated in good faith.
We'll be ready to do that
All right.
if we can't negotiate something.
I'm sure you will. All right, if there's nothing else, we're off the record in number 5. Let's move on to number 6. This is Avant Operating. There are 2 cases, 25747 and 25748.
Good morning, Mr. Examiner, Dina Bennett on behalf of Avant Operating 2.
Good morning, Mr. Hearing Examiner, Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production Company. And we have just entered an appearance and objected, but we're we will defer to the preference of Avant and Permian if they choose to set a contested hearing date.
So you've objected for negotiation purposes.
That's
And
correct.
that's all I need to know. I got it.
And Ms.
Any other entries of appearance?
Jackie McLean, on behalf of Permian Resources Operating. We have objected. We filed competing applications. Their case numbers 25797 and 25798.
Excellent. Thank you. That's helpful. Ms. Bennett?
Thank you. So the Avant cases are currently set for a contested hearing on January 27th. And at the last status conference we had on the Avant cases, the hearing examiner asked for confirmation from the other parties that the January 27th hearing date would be workable. And I have not seen that confirmation yet, but the pre-hearing order has been issued. So one of the reasons I wanted to have the status conference today is to confirm with the division and the other parties that January 27th is the contested hearing date.
All right, sounds good. Ms. McLean, before I ask you that question, have you requested your two cases to be consolidated with these cases?
And Mr. Hearing Examiner, sorry to interrupt. I just wanted to mention I'm here for WR Non-Op LLC. Caitlin Luck appearing for WR Non-Op in these two cases. No objection. Thank you.
Excellent. Ms. McLean?
We have not. We filed a total of 4 applications. Only 2 of ours actually overlap in spacing units with the Avant cases.
Okay.
So we're going to be presenting our other cases in the same well group on the January 8th docket. And because of that, we don't think that January 27th is a good date to go to a contested hearing. At the last status conference on these Avant cases, Ms. Bennett questioned whether or not we were actually going to file competing applications, and she wanted us to come back today so that we could announce the division that we had. We did file them well in advance of the deadline for the January docket. I sent Ms. Bennett those applications. We, when they object to those applications, we'll be going to a status conference on the January 22nd status conference. That hasn't happened yet. And, we'll proceed accordingly as we need to do. So we didn't think that a status conference was necessary today. There's going to be a status conference set when they object to 25797 and 25798 in January, because that's just automatic when someone objects. And we don't think that the January contested hearing date would be a good contested hearing date for these cases, because we have a full development plan. We have proposals that have been sent out to Avant. Avant, we're waiting for them to respond. And Permian Resources thinks that some of these could resolve the issues. But again, the ball's kind of in Avant's court to respond to our proposals at this point. And in the meantime, we're proceeding forward with our Colonel Freckles applications, as the deadlines permit.
Ms. Bennett, do we have a pre-hearing order for January 27th?
We do.
I thought so.
And I did object to case numbers 25797 and
Okay.
25798. And they are set for a January 22nd status conference. But, and at the last status conference, it was clear that the division was going to set a contested hearing for January 27th, and only upon a motion from Permian Resources demonstrating witness unavailability would the division consider a different date.
I think it's, Jackie, it's yours.
Oh, sorry.
Thank you.
And so I don't think there's any question that January 27th is the date
Okay.
for the contested hearing. And also, to answer your question directly, Permian Resources has not filed a motion to consolidate their 2 cases with the Avant cases.
Okay, all right. So Ms. McLean, you said you had 4 cases. 2 of them don't compete with Avant's, and so you're going to present those by affidavit
Correct.
on January 8th.
Correct.
I thought so. I haven't heard any good reason to vacate the pre-hearing order setting these cases for January 27th.
You asked if I thought that it
I'm
was still a good day.
I thought you were just answering my question.
And so I was just answering the question,
Freya-
that we did not at this point think it was a good day.
I got it. So Freya, the pre-hearing order, we need to issue an amended pre-hearing order to add Ms. McLean's cases to Ms. Bennett's cases.
Okay,
And those are 25797 and 98.
got it.
All right, sounds good.
And Mr. Hearing Examiner,
Yes.
Avant is not going to object to the other two cases that Ms.
Okay.
McLean was referring to, because in those cases anyway, Permian Resources has stayed in its lane.
Yeah.
It's only proposing 2-mile laterals that don't overlap
I
with
see.
any, I mean, Avant doesn't own any interest in those either, but in the cases where we are objecting, Permian has proposed 3-mile laterals that directly overlap one section in which Permian owns nothing and Avant owns the majority.
Okay.
And so that is the reason why we're not objecting to the other two.
That makes sense.
Thank you.
Okay.
Oh, may I ask one other follow-up
Yeah.
question? The other reason I wanted to have a status conference today, and I appreciate the division's willingness to hold one, is that Avant is interested in learning more about MRC's position. And it sounds like they're not going to be filing competing applications, but I did just want to understand that before we get too much further down the road on this.
And when you say MRC, do you mean Matador?
I do mean Matador.
Yeah, I thought so. Okay.
Yeah.
All right. Well, great. Okay. Okay, excellent. Ms. McLean, anything further?
Nothing from Permian
Okay,
Resources.
very good. Freya, what position are these cases on the January 27 docket?
I'll need to look it up. I had everything closed because I didn't have Wi-Fi.
Sorry.
But I think we have 2 cases on the 27th, 1 or 2 cases. So this would be either number 2 or number 3, but I can confirm.
All right, thank you. And then we have the following day also, right? Reserved? The 28th?
Yes,
All right,
correct.
I thought so. All right. Okay, we'll issue an amended pre-hearing order to add 25797, 25798 to the 2 Avant cases. And with that, we're off the record in these 2 Avant cases.
Thank you.
Thank you. And do we need to have yet another status conference in January on the 22nd?
I don't think we do,
You don't think so?
but if Ms. McLean thinks we do, then
Ms. McLean, I know that your cases, so they've been objected to. Where are they now? What docket are they on now?
They're on the January 22nd
Oh,
status
because they
conference
were
topic.
objected to.
Correct. I didn't think we needed a status conference today
Right.
because that
Okay,
was happening.
I get it.
But I don't think we need another status
Right.
conference.
I don't think so either. Right. I mean, if the parties miraculously resolve their issues, they can let us know and we'll vacate the pre-hearing order.
We're hopeful.
We
that
do it
they
all
are.
the time.
Yes.
So Freya, it seems to me that you could just move those administratively to the January 27 docket, saving the client $300.
Okay.
Why not?
Thank
Okay,
you.
you're welcome. All right, so now we're gonna go on to I gotta make a note here. Hold on a second before I make a mistake. So that was 6 and 7. Okay, let's go on to number 8 on our docket, and this is Targa Midstream 25757.
Dana Hardy with Hardy McLean for Targa.
Thank you.
Adam Rankin with the Santa Fe Office of Paul and Hart, appearing on behalf of COG Production LLC, Concho Oil and Gas, and EOG Resources Incorporated.
In your position?
We object to the application and we'll be prepared, we'll be prepared to go to hearing to contest it.
In other words, this is I can't tell by these letters, Ms. Hardy, what type of a case is this?
It's an acid gas injection well case.
So we should have we'll probably have, we'll have a different technical examiner for this case. And I'm spacing on, Phil Getz's group, but I'm Tony.
Anthony Harris.
It'll be Tony Harris, most likely. I doubt it will be Phil in this case. Do we have anything set, Ms. Hardy, before I go to other entries of appearance?
We do not.
We have nothing set yet. Okay, and Mr. Rankin, you've objected, but your objection is what, to negotiate?
Well, I'm not sure what room there is for negotiation. We have serious concerns about the plan to dispose in the target formation.
Similar to the Goodnight Empire case.
We'll see.
Yeah, we'll see.
I hope not.
That was clever. All right, Mr. Savage.
Yes, good morning, Mr. Examiner. Darren Savage with Abbott and Shield, appearing on behalf of Devon Energy Production Company, LP, and we have objected to this case.
And your objection? Hey, what's your object? What do you want? Why did you object?
Looks like we're going towards a contested hearing on this. Our objection is that the shallow wells would interfere with Devon's current plans and future plans and undermine correlative rights.
Okay, perfect. That works.
Good morning, Mr. Examiner.
There's more.
Dina Bennett on behalf of Coterra Energy Operating, and Coterra, like Devon and the clients that Holland and Hart is representing, has concerns with the injection and the potential to impact offsetting wells, some of which Coterra operates.
Makes sense. Thank you. Ms. Hardy.
Thank you. So Targa is working with the parties to discuss their concerns. And at this point, I would request a status conference on the January docket, because if the concerns don't get resolved, then I don't believe Target would proceed with this application. But they're still trying to make that determination.
Okay, that makes sense. When did you file the application?
It was filed initially for this is our second docket. I think it is. It was initially filed for the first November docket, but we continued it to December.
For negotiation purposes?
Yes.
Okay. So you filed it in October is what you're saying?
I believe that's correct.
Okay, very good. So then this would be on the January, Freya, what is the status conference docket in January?
It's January 22nd.
January, thank you. All right, so Ms. Hardy, please continue your case for a final status conference on January 22nd, I think you said, Freya?
Yes.
Thank you. But no, it will be the final status conference.
Okay, thank you. I will do that.
Either we'll need to set it for some sort of hearing, or you can dismiss it, or whatever you prefer.
Understood.
All right,
Thank
well,
you.
good luck, Ms. Hardy.
Thank you.
Let's go to Permian Resource cases. These are 257, 68, and 69. Entries, please.
I'm sorry, Jackie McLean on behalf of Permian Resources. Just getting confused with my highlighting.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewburn Oil Company, and we have entered an appearance and objected. I did send an email to Freya yesterday to let her know we filed competing applications, and I'm happy to give you those case numbers.
Yes, please.
So it's 25857, 25858, and 25859.
Wait, there's three of them?
There's three of them.
So
That's correct.
57 through 59?
That's correct.
Perfect, thank you.
And I sent that after we received the entry of appearance and objection to our cases, which were filed for the January docket. And I'll just state now that we would like to do another status conference. I believe it's my understanding that the parties are in negotiations right now, and would like to, I think I won't speak for Ms. McLean, but I am aware that based on our conversations or emails that Permian would like to set a contested hearing. We would like the latest possible date for a contested hearing to allow for those good faith negotiations to take place. So
when were what docket are your three applications on?
So they were filed for the January docket, but based on some of the feedback that we did receive, probably would not have made that docket and been pushed to, if they were uncontested because of the caps, so probably would have been pushed to a February docket.
Yeah, but since they're objected to, they'll go to the status conference docket on January 22nd.
That's right. I'm just, I'm pushing for time here.
I see that, Ms. Vance.
I'm
You're
pushing
very
for
transparent.
as much time as we can. So,
So since you're competing with Ms. McLean's cases, though, I give her preference because she had the original cases. So I understand you want a delay for good faith negotiations. That's great. Let's see what Ms. McLean wants.
No delay.
No, it's okay.
and I will, I just one thing, and I'll, can I follow up? I'll let Ms. Ms. McLean.
I don't
want to say that didn't sound great, but I do want to follow up on that point. I did have a question about that regarding the preference.
Yes, by all means.
I just want to understand what the precedence for that is, especially since we do have competing cases where we've got two two parties who have applied, both who have, under the Oil and Gas Act, are afforded the opportunity to produce their just and equal share of the mineral interest. So, understand that they filed first, but we do have also an interest here. So we would ask for some equal deference.
Thank
So,
you.
Thank you.
And I'll think about how I want to answer that question. And maybe I'll answer it today, maybe I won't. Ms. McLean, when did you first send out your well proposals?
Oh, gosh. The well proposals for these.
Yeah,
were
take your time.
Sent.
I'm not rushing you.
All right. They were sent back in September.
So Ms. Vance, going to your point about good faith negotiations, as an additional piece of evidence, Ms. McLean says that her client sent your client well proposals back in September. So that was 3 months ago. Okay, now I realize that you've just filed your competing applications. I got that. And we want to give your party the same due process that we want to give Ms. McLean's client as well. So Ms. McLean, when do you want to hold a contested hearing?
Yes, I believe that we would like the available February hearing date.
That's 2/10.
Yes, February 10th.
All right. So Ms. Vance, I'm inclined to grant that unless you can provide some very good reason why you're not prepared to go to a contested hearing in a month and a half from now.
That's a very short time frame. For one, we've got the holidays going on. We're coming back from that. I don't have all the specifics in terms of when, I understand that those proposals went out in September. I don't have a lot of detail, at least from my end, on how those were, Mewburn has evaluated those proposals and sending out their own proposals. I don't have the date when those went out from our end. I'm trying.
Let me interrupt you for a moment.
Sure.
Your competing applications have been filed and are ripe for a hearing by February 10th. Actually, before that. So that's what I'm thinking of. I want to make sure that we comply with all the rules. And I want to give you time to negotiate. Seems like February 10 gives your client some more time to negotiate, gives them a month and a half from now to either finish negotiation or, step up to give us some evidence on why your plan is better than Ms. McLean's. If you have some serious problem, you can negotiate with Ms. McLean. And if the parties file an unopposed motion to continue, we might do that. But I do want to abide by, based on everything I've said so far, what I'm hearing from Ms. McLean and from you, February 10 should be a good date for a hearing.
Well, I would have to confer with
Of
my
course.
client to make sure that they were available. But again, I would just reiterate, we'd like to have that additional time for negotiations, fruitful negotiations. And I would just reiterate, we would have a strong preference for, if we are going to set a contested hearing date, for it to be the March date. That's just too soon to do February docket or contested hearing.
Okay. If you want to file a motion as to why that's too soon, feel free. It may be opposed, and I do need to look at both sides of it. Include any affidavits or evidence that you have that supports that position. But it seems to me that many times it's all about negotiating. And since these have been sent out in September, seems like your client has had a lot of time to think about these. They filed competing applications for a reason. And so, I want to give your client the same due process rights as I'm giving Ms. McLean. So is there anything further?
No.
All right. Thank you, Ms. McLean.
Thank you.
No, nothing
No,
from us. Thank you.
We're off the record in 9 and 10. Let's move on to Permian Resources 25770. Entries of appearance, please.
This
Number 11.
number 11, this should be consolidated with the 25768 and 25769. The three of them were all filed together.
I didn't know that. All right. So Freya, would you do that?
Yes.
Would you also, consolidate with 25857 and 25888? So I'm sorry, let me start again. 25857 through 59,
Yes.
the three cases that Ms. Vance filed. Okay. So we've called that case, and Ms. Vance, you're on that case as well.
Yes, and I would say, can we come back for
Yeah,
another status conference in January?
Sure. I
Okay,
don't see why not.
perfect.
It's up to you to file the continuances. Well, for you, Ms. Vance, your case will be on.
It would be automatically set for that, but I just wanted to confirm, I did have some email correspondence with Ms. McLean
Okay.
yesterday, and, I did want to mention that we filed those competing
Yes.
applications and make that noted for the record here today, but wanted to confirm that we would go ahead and do that status conference in January as well.
Sure. We'll consolidate the 6 cases together, Ms. McLean. You don't have to continue your cases to that docket. We'll hear your position at the time we call Ms. Vance's cases. So then it'll be up to you to continue your cases to the February 10 docket after we have our status conference on January 22nd.
Understood.
All right.
Thanks.
Anything further?
No.
No. Ms. McLean?
Nothing.
All right. So then we're off the record in that case. Let's move on to number 12, Matador Production 25584.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of Matador Production Company.
Will you spell your name?
Yes, Raylee.
Okay.
Starnes, Starnes.
And you're representing Holland and Hart. You work for Holland and Hart. You're representing Newborn.
Matador.
Matador. Thank
Yes. And I don't believe there are any other appearances for this. Case 25584 is an application to amend order R22860 to add additional pooled parties and was continued from an earlier docket to perfect notice.
We're off of our status conference.
Yes.
Okay, here's what we're gonna do. Since basically all the cases, with the exception of 4 of them, are gonna be taken under advisement, the only role I have today is to admit the evidentiary packet that may have been filed by the request of the technical examiner or myself. So let's just jump to the chase. Is there something you want me to accept into evidence?
Yes, if there are no questions, I would like all the exhibits be accepted into the record, taken under advisement.
What did you amend?
We revised the hearing packet to update the self-affirmed statement of notice and
Okay.
the affidavit of publication, showing that the additional party has been properly noticed.
All right, so this was a notice cure.
Yes.
All right, so let's see something here. This is number, okay, yes, I have a note on this. Okay, your amended or revised exhibits are accepted into evidence, and we'll take your case under advisement.
Thank you.
All right, we're off the record at number 12. Let's move on to number 13. This is 25663 Mewburn Oil.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewburn Oil Company.
Jackie McLean on behalf of ConocoPhillips, COG Operating, COG Production, and Marathon Oil.
Perfect, thank you. Have you seen the revised exhibits?
Yes, and we had emailed counsel for Mewburn yesterday asking that Conoco be removed as a pooled party because the deal hasn't closed and they don't expect that to close until sometime in January.
Okay.
But other than that, there was no objection.
So I would ask that we do another status conference because it's my understanding, we were hoping to be able to have something in writing.
I see.
We haven't gotten there, as Ms. McLean has stated. But right now, I would request that we have another status conference. There's been a lot of back and forth on these. These were filed, refiled. There was another party involved, PBEX. And so now there's some negotiation going on with between Mewburn and COG. But again, we would just ask if we can possibly do another status
Ms.
conference.
Vance, before you go on, we were here today not for a status conference, but to continue the hearing by affidavit. So what you're saying is you're not prepared to continue the hearing by affidavit because you're in ongoing negotiations to basically clean this up.
Yes.
Okay, fine. So
yes.
then why do we want to have another stats? Why don't we set it for another hearing by affidavit? That way, if you've cleaned it up, there won't be an additional delay for you, and I'm trying to not delay your cases.
I'm happy to do that.
Yes.
If the
When you
hearing,
want it, it's up to you.
It's my understanding that the closing will occur in the first like 10 days of January.
Okay.
So
so
February docket would probably be safe.
we don't really want to go that far. If we, I
Maybe a
guess,
special docket? Add
yeah,
to a
if we-
special docket?
so maybe if we could.
All right, hold on
file-
a second.
Sure.
So Freya, do you have a special docket in the middle of January or the end of January?
We have January 13th and January 27th.
Did you hear that, Ms. Vance? Because you were talking, Ms. Vance. I'm getting a question answered for you. Will you say that again, Freya?
January 13th or the 27th?
Can
Which
we,
one?
let's do the 13th
You want to
and be optimistic.
Okay, so you're going to continue your own case. We're not continuing it, Ms. Vance.
Correct.
You're going to continue it to, and I want to write this down. The hearing by affidavit. Is this your witness, by the way, Mr. Kerms? Kermsey?
Sorry, good morning, Mr. Examiner. I'm with Brad Pute Sayer, representing PBEX operations.
I didn't know that. Okay,
Yeah.
I don't have you as a party in this case. I didn't know that.
Yeah, we filed on the 5th and notified the parties on the 5th.
Of December.
Yes.
Freya, do we have an entry of appearance from this gentleman?
I looked into it this morning on, after receiving an email from Jennifer Bradfute. I looked in our system. The entry of appearance was submitted as was created as a draft, but it was never formally submitted into our system for acceptance. Ms. Bradfute just filed, my understanding is she just filed an entry of appearance this morning.
Okay, that's why you're not on the list, Mr. How do you say your name?
Kermsey.
Kermsey, sounds good. Would you spell your name so that we can pick it up?
Yeah, it's Kirmse.
Your first name?
David.
Okay. All right, so did you file an objection, Mr. Kermsey?
No issues.
So then you're just monitoring this case?
Yes, absolutely.
All right, thank you. Ms. Vance, back to you.
Yes.
Please continue this case to the January 13 for a hearing by affidavit. We will act as though that's today. What we were going to do today, we'll do on the 13th, okay? And hopefully you'll be ready to proceed. If not, we'll just bump it down again.
Thank you. I appreciate that.
Yeah, no problem. Okay, if there's nothing else, Ms. McLean, anything else in this case?
Nothing from us.
Okay, thank you. Let's move on to Matador Production. There are two cases for our hearing by affidavit continuance. This is 25697, 25699.
Mr. Examiner, Jim Bruce, representing Matador Production, MRC Permian. There is no opposing party.
Go ahead.
This matter was heard a couple of weeks ago. It was continued to correct the first page of each pooling checklist to reflect that the well units are standard. That has been done. And as a result, I would just simply request that exhibits A through F in each case be admitted into the record and the cases be taken under advisement.
Okay, admitted without exception, taken under advisement. Thank you, Mr. Bruce. Off the record. Let's move on to 3R operating case number 16-25707.
Yes, Jackie McLean on behalf of 3R Operating.
Thank you.
And in case number 25707, we submitted a notice of amended exhibit packet as requested by the division to include an amended compulsory polling checklist, amended C102, and amended stratigraphic cross-section. And I ask that this amended exhibit packet be admitted into the record and that the case be taken under advisement.
Admitted without exception, taken under advisement. We're off the record in 16. Let's move to 17, COG operating 25712.
Yes, Jackie McLean on behalf of COG Operating. In case number 25712, COG submitted an amended exhibit packet to include an amended compulsory pooling checklist and an amended tract ownership exhibit. I ask that the amended exhibit packet be admitted into the record and that the case be taken under advisement.
Thank you. Admitted without exception and taken under advisement.
And Mr. Hearing Examiner, Riley Starnes with the Santa Fe office of Holland and Hart. That's okay. Making an entry of appearance on behalf of Matador Production Company, just monitoring.
Okay, thank you, Ms. Starnes. Moving on to number 18 on our docket. Well, it looks like it's consolidated with another case, although it looks like maybe one of the cases was taken under advisement, Miss.
Yes, Riley Starnes with Holland and Hart, representing.
Let me call the case numbers
okay.
and then you can enter your appearance. 25713, 25714, and not calling 25715.
Yes, Riley Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company. And for 25713, 25714, we were filing revised hearing packets to correct a pool and pool code.
And have you done that?
Yes, so they are filed. I do believe there's one entry of appearance, perhaps.
Maybe Ms. Luck?
Yes, and Caitlin Luck for Vicky Meadows and Bo Bays and only 714, excuse me.
So we have filed our revised hearing packets reflecting the updated pool and pool code. And if there are no other questions, we would ask that the revised hearing packet and exhibits be admitted into the record and taken under advisement.
Admitted without exception. And these two cases are taken under advisement. What happened to 25715?
I believe it was taken under advisement at the last hearing.
That's what I thought. Thank you. We're off the record in those cases.
Thank you.
Let's see now. Looks like we're calling Newburn Oil. This is 25726.
Yes, Jackie McLean on behalf of Newburn.
Thank you.
And in case number 25726, Newburn filed an amended exhibit packet to include an amended non-standard unit offset interest map by track and an amended compulsory pooling checklist for the order that we are asking to be amended. With that, I ask that the exhibits be admitted into the record and the case be taken under advisement.
Thank you. Admitted without exception and taken under advisement off the record in case number 20. Let's move on to 21. This is 25728, consolidated with some other cases that we came back to receive additional information. 25730, 31, 32. I'm going to call 33 separately. So we're not going to call 33 right now. So let me hear entries of appearance for those four cases.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Matador MRC Permian Company. And we filed revised hearing packets in each of these cases for all of them for correcting the pool code and pool name, which we did that in the CPAC as well as in the landman statement, and then the updated C102s. And then in two of the cases, 25730 and the one case you did not call, we also updated the CPAC and the land statement based on Mr. McClure's feedback regarding what Permian would be allowed to pool because of a depth severance carved out specific to the second bone spring. So based on that feedback, we limited each of these to the third bone spring. So and I would ask that the revised hearing packets and exhibits be taken under advisement at this time if there are no questions. And we do have our experts available if there are follow-up questions.
There are not. So your amended exhibits are admitted into the record without exception, and your cases 25728, 30, 31, and 32 are taken under advisement. Now let's call 25733.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant MRC Permian Company. And I won't go through everything.
Let me tell you the reason I called it separate, because you didn't sign the CPAC.
Oh,
Yeah, so we're going to call that a typo. Please sign it today. As long as we receive this by 5 p.m. today, we will leave that record open. It won't stay open after 5 p.m. today.
it will get done. Excellent. I appreciate that.
So we will receive your exhibits into evidence without exception including the signed CPAC, even though I don't know that is an evidentiary document or not. And we will take your case under advisement at 5 p.m. today.
Absolutely. Thank you.
Thank you. We're off the record in all those Matador. We only have one case left, and that is number 26 on our docket. It is 25767.
Jackie McLean on behalf of Spur Energy Partners.
Thank you.
And in case number 25767, this was just called back so that the public notice period could run. It did not get published in time due to the holiday. So I asked that the exhibits be admitted into the record and the case be taken under advisement.
Thank you. Without exception and taken under advisement. So thank you.
Thank you.
And for that, we conclude our hearing today. Thank you for everyone's,
Mr. Examiner, could I suggest a point
yes,
or order
Go ahead.
perhaps?
Yeah.
And, the division does prepare this worksheet, which is super helpful. And I was just wondering, to avoid attorneys talking over each other, if it would be helpful for the division if we entered our appearance when there's multiple parties in the order listed on the worksheet. And that way we're orderly between the folks who are virtual and the folks in the room. And also can make sure that way that we're not stepping on each other's toes when we're trying to enter our appearance.
It makes sense. And if you can email your fellow attorneys and let them know that that seems like a very good idea to me, because some people are not here. They may not be hearing this, but I think it's a wonderful idea.
Great. Thank you so
All
much.
right, thank you. All right. Unless there's anything else, we're off the record. And a Merry Christmas to everyone. I don't think we have anything else for the rest of the year. Do we, Freya?
We do not.
All right. Excellent. Happy New Year or happy holidays, however you celebrate it. And we'll see you in the new year. Thank you.